So now let's understand about Article 25, which deals with mutual agreement procedures. Now, a treaty is kind of an agreement between two countries, let's say India and USA, right? And then there are tax authorities who are involved, right? And there are taxpayers. Now, what can happen is many a times the tax authorities, in their drive to calculate taxes, may act aggressively, right? And not necessarily be in accordance with the provision of the treaty. In such a case, if there is a taxpayer who believes that the way he has been taxed in the other country, if he is taxed in his home country, let's say we are talking about a US taxpayer, if he is taxed in his home country adversely, he has domestic remedies available to him. Just like in India, if the tax department acts aggressively, you can file an appeal. But if he is taxed by the other country, let's say India, okay, in a manner which he believes is not as per the terms of the treaty, then he can just go and ask his competent authority, which is a delegated authority of the government, to initiate a dialogue with the Indian competent authorities. And what is done is that as a procedure, the two of these authorities, which is both India and USA, are going to try and interact, meet, present their viewpoint in terms of why the tax treatment which is meted out to a taxpayer may be correct or not, right? And arrive at a decision which is kind of communicated to the taxpayer. Then it is up to the taxpayer whether or not to accept it. The procedure through which this entire exercise is done is known as a mutual agreement procedure. A procedure wherein the contracting states, both of them, mutually agree, right, to a particular point. They may agree that a person has to pay taxes. They may agree a person doesn't have to pay taxes, right? Or they may agree to disagree, which is that both of them believe that one believes that there has to be tax, the other believes there is no tax. But then they are not able to convince each other, so they agree to disagree. So let us understand what is the meaning or the definition of this term mutual agreement procedure, right? While I've used the word definition over here, this does not refer to any standard definition, but it's just a simplified form which we've tried to put together to communicate the meaning of mutual agreement procedure, or MAP as it is generally called in international tax parlance. MAP is a special facilitative procedure. It's a special because it is not that it is applicable in each and every cases. While you can invoke it because it is the belief of the taxpayer which is the triggering point, it is not necessary that every time you trigger a MAP, the tax authorities or the competent authorities will accept it. Second, it's a facilitative procedure. It's not a legal procedure. So therefore, as every facilitative procedure would have, the idea behind these discussions is very flexible. It is not that they have to meet 10 times in India, 10 times in US and things like that, but it's a procedure to facilitate arriving at some conclusion. Set out in various tax treaties, okay? So it's forming part of the tax treaties that allows designated government representative. When I say designated government representative, normally this is referred to as competent authorities. So competent authority of India, competent authority of USA, to work together and resolve international tax disputes. It's not about a domestic tax dispute, it's about an international tax dispute arriving out of the DTAA, including cases of double taxation arising out of application of the convention. So by virtue of application of the treaty, if there are cases whereby a double taxation is triggered, right, wherein both the countries believe that they have the right to tax, then these competent authorities can get together, identify what is to be done, and then move forward accordingly. Now let's look at what all is MAP applicable to, right? The answer to this is it is applicable to all the articles, right? But specifically, most of the time, the issues which arise in MAP, not in any particular order, are for business profits and PE, right? Even though existence of a PE is a fact-finding thing, right? Many a times you find that there are controversy in terms of application of the legal provisions as well. Associated enterprises, whether two companies are AEs or not within the meaning of Article 9. Dividends, interest, royalty and fee for technical services, and elimination of double taxation. Like I said, this list is by no means exhaustive. It applies to all other articles of the conventions as well. The implementation of MAP is vested with the competent authorities of the treaty countries. So in every country, there is a competent authority which is entrusted with dealing with the cases of MAP. Now, while the implementation of MAP is vested with the competent authorities of treaty countries, there are domestic provisions which deals with how this is to be taken forward. In India, the relevant rules are Rule 44G and 44H. We are just going to look at the content of these rules in Indian context in the next few slides.